getting debts within the reasonable time. How do you intend to give courts like the commercial division, which is sometimes unfairly accused of having lost its identity, the labor court, which is sometimes unfairly accused of being pro-employees court, the land court, which is also sometimes unfairly accused that it is a nightmare to get a hearing date from that court. How do you want to give those three divisions or three courts an identity?
Yes, the accusations are there, I've heard them. But we must understand the background why we have these accusations. It really boils down to numbers, judges. So when you hear that your matter that you filed in 2020 will not be heard until 2025, then you know something is wrong. So to begin with, the identity that they must be given is expeditious disposal, which they can only achieve if they have the numbers. They can also get that identity by being active in case management of the cases that are before them, to be able to identify which cases have been there long, and to identify those cases that are urgent in nature. But the whole thing boils down to capacity. Thank you.
And lastly, another nightmare facing the judiciary or the administration of justice, my lord, is the Mariotetu case. The Supreme Court, respectively in my view, dealt with the circumstances, the degree, gravity, and the culpability and the exceptional nature of the death penalty in terms of Section 203 as read with 204. And what the court said, from my reading, I could be wrong, is that the two accused persons, and the court, let me start by saying, this decision, the court was very specific and said it only applies to these two petitioners, Mariotetu and Mangi. Again, the court did not set aside the death penalty, which was imposed by the High Court and also upheld by the Court of Appeal. But they remitted back the matter to the High Court for resentencing. And what the court was saying, in my view, is that a formal equal penalty for an equally wicked crimes and criminals is not in keeping with the tenets of a fair trial. And the court said, anybody who thinks there is a problem of the death penalty need not to approach us, but go to the relevant court, and then they come to us. And they said, the AG to set up a framework to deal with the sentence and rehearing of cases relating to the mandatory nature of the death sentence. Of course, the point I'm raising, my lord, is that there has been a remarkable concerns that that judgment has been misused and abused and misunderstood and misinterpreted by all the courts, from the Court of Appeal to the Magistrate Court. And now it's free for all. How do you intend to resolve that nightmare as CJ Ouko?
Thank you, my lord. On a light note, I think Kenyans must be wondering this Muruatetu man that is being discussed in this tent from the time we started. Perhaps the commission may want to introduce him at the end of your exercise. He's a great guy. He very resilient. He brought a change to our jurisprudence. Muruatetu, a very resilient man. Having said that, perhaps we go back to the decision of the Court of Appeal just a month before the promulgation of the Constitution, the Ngothom Mutiso, where the court was faced again with the 204 crime, section 204. And the court was very specific. The court said this decision is limited to this case and to the mandatory nature of death sentence under section 204. And it went on to say that it perhaps may apply to the other capital offenses, and they named them: treason, robbery with violence, attempted robbery with violence. They said a day will come when that will be resolved. But for now, Ngotho's case ends with the determination that death penalty is not the only punishment that you can be given when you commit murder. Then, of course, came a 5-judge bench of the Court of Appeal a few years later in the case of Joseph Mwaura, and the same question arose, except I think Joseph Mwaura was robbery with violence, but the principle of the mandatory nature of the death sentence was still at the center of it. And the court said, we have no alternative. The law says you murder, you commit robbery with violence, it is death, nothing less. Then the Supreme Court came. The Supreme Court agreed with the first case, Ngotho, and said what it said. The two issues that I think have been raised, that after that decision, there's been confusion. I think the courts and the practitioners ran to town. The Supreme Court had said, hold, they had actually said what Ngotho said, that this case relates to the circumstances of this case. But the Supreme Court, in my view, said two things that perhaps has caused the confusion. The first is, I think, paragraph 48, which I think people have misread. Paragraph 48 of that decision, the court says that you cannot take away discretionary powers of a court in sentencing by an act of parliament, that is not the role of the legislature. Of course, they've gone on to explain again that it was really in relation to what they were saying. Personally, I don't think they were saying it generally. Then they asked the Honorable the Attorney General to come up with a framework, what they call structural interdicts. And I think perhaps people waited and became impatient. There was no direction, and we took the law in our own hands, hence the confusion. I can't blame the Supreme Court. Had we held our hands, had we waited for the framework, perhaps this confusion would not have been there. So what I'll do, if you allow me to be the Chief Justice, because the Supreme Court did not finish its work. It gave an interdict. Have a mention and hear what the Honorable the AG has to say with regard to the assignment that he was given, now nearly 3 years, and you make a decision from there. Thank you, my Lord.
Thank you, my Lord. I wish you well. Thank you, Professor.
Thank you, my Lord.
Thank you, Judge Wasame. Thank you, Your Honor. I think we'll have now questions from Commissioner Judge Majaja before we take a break. Commissioner.
Thank you, Chair. Good morning once again, my Lord.
Good morning, sir.
One of the tasks I've been given is to deal with your writings, not necessarily to interrogate the reasons, but just to satisfy the Commission that you meet the standard, and I must say that they are very impressive. We have 4 judgments. The first one is in a civil appeal, Kenya Hotel Limited and Oriental Commercial Bank. Another one in Elizabeth Wambui Githinji versus Kenya Urban Roads, and a ruling in Judicial Service Commission versus Honorable Lady Justice Kalpana Rawal. What I read from those decisions, first of all, they are individual judgments. In 2 of them, you actually delivered the majority decision, and there were dissenting decisions. I think one of the issues I had raised with your colleague, and probably you followed that debate, and you mentioned it, is the level of accountability for individual judges in the Court of Appeal or in a collegiate court to the public, being able to write your own decision. And my view and assessment, and correct me if I'm wrong, over the period, the Court of Appeal has not done very well. You've been writing joint judgments, and when I look at other courts of your status, Supreme Court of Appeal South Africa, there are 5 judges, but normally, even when they agree, it is one judge who writes and he's identified. Look at Tanzania, look at Ghana, that's what happened. So maybe you want to tell the public why this is a different position. And in fact, if you look at the old East Africa Court of Appeal, that was also the position. That's why we know Madan, that's why we know Newbold J said X, Y, Z. Why is that?
Yeah, thank you, my Lord. Yes, it is very important to not have known Nyirangi was a great judge, but his decision, one decision that has stood the test of time, the Lillian S, has his name on it. And so I can't overemphasize the need for a collegiate court to have separate opinions. It is in our court, there are those who think we should be doing separate judgments, but there are those who think that the reality is that the numbers cannot allow us to do that, because if you hear one matter and each one of you has to write a reasoned judgment, the time you take to do that in one case you'd have done 2 others. So that's one reason, not a very persuasive reason, but it's based on the current number of judges. And we had actually resolved that when we get the 11 judges, that is going to be the way, because it is provided for in our rules as a general rule that to begin with we must write single judgments. And so I want to admit to the public that that's one area that we haven't done very well on account of our capacity.
Because, and I agree with you, it's not a very good reason, because it is one judge who writes. Once you agree, you conference, you say, Judge so-and-so right, and the rest just concur. So it doesn't add, unless the case is of such magnitude that you feel that you need to write single judgments. It's normally you agree as a panel, and then one judge writes and the rest concur, and that's what I've seen in the other jurisdiction. But let me go to the next question, and this is a quote from a young jurist called Walter Kobe on the Court of Appeal. It's a quote, it's out there, and it says as follows in the platform. If there's a group of people whose ideology is contrary to the spirit, values, and principles of the 2010 Constitution, it is the judges of the Court of Appeal. In fact, if there's a group of people who are irredeemably mired in a legal culture of liberal legalism, that is formalism, positivism, rule-bound technical approach to adjudication associated with the pre-2010 dispensation and are oblivious to the demands of change in legal culture demanded by the 2010 Constitution. It is the judges of the Court of Appeal. So this is criticism. So, as the president of this court, is this statement true? And probably you would give me examples or give the public examples why you think this statement is not true or correct, as you may.
I'm actually surprised. We thought we were doing our best. We thought we were progressive. And so I do not know where Mr. Kobe did his research, if he's able to identify decisions that he thinks are not progressive, because that's what we encourage. Even among ourselves, we sometimes reflect on our decisions where we have gone two different ways. And we have invited people to come and talk to us from the academia, from the legal practice in the court, in order to be able to have this robust jurisprudence that we talk about in the judiciary. So really...
so can you give us an example of what you consider progressive jurisprudence from the Court of Appeal?
There are many, my lord. There are very many.
Because you have to answer this question, so give us 2 examples.
We have made decisions in election petitions that have gone to the Supreme Court and upheld, and so many other decisions. All this Muruatetu and all these things we are discussing all pass through the Court of Appeal. So I think it is unfair criticism without detail. And so it's to answer...
So for example, he says Mitubel, one of the decisions he discusses, the decision of Mitubel.
Right.
Of course, Mitubel has now been overturned by
Supreme Court.
The Supreme Court. This decision which you quoted, this one of the decisions in your this position in Elizabeth Wambui, the one you gave the majority decision. Another one, for example.
Mitubel, yeah, so it's good when somebody criticizes and gives you an example, then you are able to respond. Of course, the Mitubel, the main reason was the way the Court of Appeal did not reflect on the issue of structural interdict. I think that may be a valid criticism. Okay. I want to admit. I don't know what the problem with Wambui case was.
This is, in fact,
the Runda?
Yes, the Runda case,
right.
About illegally acquired land.
Yes.
And in that respect, I think there have been several decisions that are conflicting on how the courts should deal with the illegally acquired land from the Court of Appeal, and that has actually caused a lot of concern in the lower courts. The Court of Appeal has given conflicting views on that particular issue.
Yes, I can talk about the Runda one. It is more or less Mitubel, if you asked me, except maybe for the area where these people are. They are in Runda. Mitubel was Mitumba village. But save for that, if I sat in Mitubel, I would have done the same as I did in the Runda case, because these are people who settled on that land from the 70s. The road on which they say to have encroached was built, and cars drive through it. The surveyor, government surveyor, confirmed that that stretch of the road, the width was 60 and not 80 meters. And what was going to happen to nearly 300 families was to have their homes demolished. Some homes were 35 million. That's not really a big consideration, but the fact that they had titles issued by the government, the fact that the survey was done by government surveyors. So I would say that if I sat in Mutubel, I would have come to the same conclusion like the Runda decision.
In Mitubel, the court seemed to cast doubt on prescriptive rights. If you read the decision, they seemed to suggest that prescriptive rights are not permitted. You are aware of that?
Yes.
Yes. But then in a very decisive case in Malindi, when you were sitting at Malindi, in fact, this is a case where the 3 judges gave very considered opinion on the constitutionality of adverse possession. You recall Mtana Lewa?
Yes.
Very detailed, and you rebuffed any suggestion that prescriptive rights over land are unconstitutional.
Yes.
So, do you think it's right for the Supreme Court to cast doubt on prescriptive rights, particularly when that was not an issue before them?
That's a tricky one also, because Article 163, I'm bound by their decision, and I can't say that they were wrong. I can only say that we decided Mtana Lewa on the matter that was before us, the question being, is adverse possession unconstitutional? And we said it is not, because there are procedures to be followed, there are conditions to be satisfied before you get title under adverse possession. The possession is not arbitrary. That's what we decided in Malindi.
My position is really, and the question I'm asking this is because you'll be sitting in that court, and just as we have been discussing, the obligation of the court is to be careful about what they talk about, isn't it? They're very circumspect. And by the way, probably that is why the Court of Appeal is always condemned sometimes, because you actually sometimes take a narrow view of the issues you have. So in Mitubel, the issue was squatters on public land. But the court went ahead and suggested, and that's why I'm asking you whether that's a correct assertion by an apex court. It suggested. So you sitting as an appellate court, would you approach that issue in that way?
One thing I was taught when I joined the bench as a judge, having been in administration for so long, those old Court of Appeal judges told me that decide a matter on the basis of what is before you. You may have great ideas you want to put in a matter, wait until the occasion presents itself. And so you're right that we are very, very circumspect when it comes to the matters that we deal with. If you think that you do not want to be bound by a statement that was made, what colloquially would be called out of context or in per curiam, then you go for the main decision that the court made, and you do not have to follow what was not before the court.
And now this brings me back to Muruatetu, because again, it goes to the same way decisions are made. So you have told us, and again, correct me if I'm wrong, the issue in Muruatetu concerned Muruatetu, this man whom we talk about but we don't know. He has been sentenced to death. All the court was saying is that the mandatory death sentence, just as the court held in Mutiso's case, the same thing, but that was pre 2010. This is after 2010, reaching the same conclusion that death sentence is not mandatory, or the mandatory nature of the death sentence is unconstitutional. What did your court, and again I'm saying this because it's your court, say about Murwatetu in respect of sexual offenses?
Yes, again, we just borrowed paragraph 48 that we have been given guidance by the Supreme Court in the sentence where they said discretionary powers cannot be taken away by a statute. And so we ran to town. We are now applying it in sexual offenses. And I believe there are other offenses where perhaps other courts are applying it where we have minimum sentences. As I say, it is not neat because of the confusion it has brought to the judicial system.
So the court is, basically what the court in Murwatetu was saying is the legislature cannot take away judicial discretion, cannot take away the judicial function and arrogate it to itself. That was the principle. So what is wrong with a court anywhere sitting saying, the court, forget about the offense, what is wrong with a court sitting anywhere saying that this is what the Supreme Court has said, there is nothing wrong? Is there anything wrong? Because that is basically the decision, that is the foundation of the decision.
Yes, and I said we had a similar decision in 2019. No, it was July 2020, the Ntisongotho. But people didn't run to town. We did not interpret it to mean, and they said the same thing about discretionary power. So I think as a general rule, really, that's the law, that the powers of the court cannot be taken away when it comes to issues of sentencing. But it's the way it is being done now, that appellants from the Court of Appeal go back to the magistrates' courts, irrespective of the offenses, and they're having those sentences reviewed.
So who can you blame? No, let me not ask that. So actually, the fact is, Supreme Court made, so who are you blaming for that particular mess? Who are you blaming? Because people are entitled to go to court anywhere.
I don't want to blame anybody. I want us to get a solution to the problem.
Okay. Now, there is another case, again, which this case of Kalpana Rawal and others, JSC versus Kalpana Rawal. And again, it's one of the decisions you gave, and this was a 5-judge bench. All the judges gave separate decisions, I believe because of the magnitude and importance of the decision regarding the right of appeal. The Supreme Court has now come up with another right of appeal, and I take this from my colleague, restlessness of jurisdiction. It is called restlessness. And I call it residual jurisdiction, coming from Newton and the cases. So what is this residual jurisdiction?
In relation to Newton?
In relation, actually, let me take, in this case, you were very clear, and this is what I always understood, that a right of appeal can only be conferred by the Constitution or the law.
Yes.
That's what the court was saying here. And in light of Section 163, the right of appeal to Supreme Court on constitutional issues, it meant that, in fact, there was a right of appeal to the Court of Appeal. Am I right?
You're right.
That was the law. But there is another residual jurisdiction that has come up that says, and this is, says, if there is an error so grave the court must be able to intervene. That is the neutral jurisprudence. Are we on the same line?
Yes.
Yes. So what is the problem with that kind of decision? What do you see going ahead where you sit? We've already talked about the problems in Moruatetu, in the other cases. Now let us look at this residual jurisdiction problem.
Lord, I think I said at the beginning that there are many issues being raised about decisions of the Supreme Court. And I said also that the Supreme Court has been giving us, in many cases, the ones that they're being criticized are isolated. By and large, we've been getting guidance from the Supreme Court. Hamana's Koinange investment defines the jurisdiction of the Supreme Court. And now, from what people are saying, there seems to be some mix-up, that the door seems to be opening. Yet in the Koinange investment, the Supreme Court said that there's a sieving mechanism, just the way you sieve tea. Tea leaves remain in the sieve, and only pure tea goes into the cup. That this mechanism ought to be strictly followed. But again, there's been talk that the door is opening wide and wide. And that brings me to what I said earlier, a time for us as a court to take all these things with our stride, sit together as judges, get all these areas where we are being accused, wrongly or rightly, that we have overreached. Let us reflect. Let us get scholars to look at these areas that you are identifying. This is the road. You have left the track. It is only through that courts, for me, it is all very well. If you criticize the court where I work, just show me the instances and we will look at it. It makes us wake up that there are people there who are watching us. The Supreme Court is so important to this nation that we must, as judges in that court, take these criticisms seriously, because institutions are run down when they bury their heads in the sand. We need to take criticisms positively and address them.
Okay. There is a case, one of the major cases you'll be dealing with are election petitions. You are aware of the decision in Martha Karua. You know the history of the Martha Karua case from the High Court, Court of Appeal, Supreme Court, High Court again. You know the history.
Yes, I do.
You also know that it went to the East Africa Court of Justice. It awarded Honorable Martha Karua damages for infraction of the Constitution. One of the commentators, again, I like reading criticism or comments, is called Caxton Higata. He calls this a legal court and the Supreme Court. As a chief of that court, is this something that would concern you, that people have to go outside the country for relief against what the Supreme Court itself has done, and how would you propose to deal with that kind of situation?
Of election disputes. I sat in the initial one, in the Martha Karua one. We had hardly 4 days to the end of 6 months, I think so. In fact, I sat with my brother, Commissioner Warsame, and Judge Musinga, and we debated, is it worth taking back when they have 4 days? Where is time to be able to call evidence? But we said that is for that court to decide. We do our bit and send it back. And so it has rolled across the borders of this country and back. So again, without casting any aspersions, again, really just to review all these things. If it's the law, we are able to recommend what laws need to be amended or made. But the big
Your reflection on this particular case.
reflection will have to be collective.
No. Now you're the Chief Justice, you're concerned because it would undermine the position of the Supreme Court if every litigant kept, when they leave your court, they go to East Africa Court and they are awarded damages. You can imagine what that does to the credibility of your court. So there must be something you can think about and you tell us that when I'm Chief Justice, this is what I would do.
Obviously, the credibility of the court suffers when people have to leave Kenya to go and seek redress outside Kenya. I really do not want to say more than I've said regarding the Supreme Court and what I will do when I get there, if you give me the chance, will to ensure that this does not happen, because we will have collectively to agree on how to deal with this situation.
Okay. Now, there is a doctrine called the political question doctrine in terms of constitutional adjudication. Can you just briefly explain to us what it means and where it finds its place in the Constitution, if it does, and where it finds its place? The political question doctrine.
Sorry to ask, is it something to do with justiciability?
Yes, sometimes referred to as justiciability or the political question. The court saying, this is a political question, we will not deal with it.
Right.
So does it find its place in the Constitution, or what is the basis for the court saying that this is a political question?
I can't right away think of the provision in the Constitution, but there are disputes that are better resolved through political mechanisms. I know long time there would be issues of nominations by political parties, violations of rules and constitutions of political parties that the courts would be very reluctant to address. So I can't recall exactly what provision it is at the moment.
So is it an issue of, again, on the same point, is it an issue of jurisdiction or is it an issue of avoidance?
I think it is avoidance, because avoidance is to avoid flogging the Constitution too much. To avoid is to return certain matters to where they belong. And so I think this is one of those instances where avoidance can be used.
Okay. My last question, which we've asked all candidates, the court which you preside is the one, I believe, that has suffered most because of the 11 judges. In fact, one of your key, what I would say, limiting factors to your success, you have been successful, and for example, you have 67% satisfaction amongst the public. But what is holding you back is those 11 judges, isn't it?
Yes.
Chief Justice Ouko, what is your solution to that issue?
Very true. My court has actually felt the brunt of this. When I joined the court, we were 20. No, sorry. When I joined the court, we were 27. Shy, the 3 judges shy to the complement under the Constitution. 27. And work was smooth. We didn't have to sit the way we are sitting now. And with time, this number has been dwindling. Judges have retired, judges died, and so we are 15. 15, if you take away myself, if you take away my Lord, Commissioner Warsame, if you take away the Director, Mr. Justice Ntoinoti at JTI, you have 12. That's a court that we sit 3. So 12 would translate to 4 judges. 4 judges dealing with appeals from nearly 200 judges from the courts below. And so we felt the weight because of this. And so when I talk about what we've gone through, it is really from my heart. There ought to be a way out. And for me, if you graciously give me the opportunity, I'll come back to you. I'll come back to the commission. This is where it all started. To retrace our steps, to find out where the rain started beating us, to find out, as it is now, I can't tell exactly where the stalemate is, but I know there are cases. I don't know the nature of those cases apart from what we read in the papers. So I'll come back to the commission. And depending on what I get from the commission, and depending on what the commission thinks, of course, I personally, I'll have my own view that the solution lies with the head of state, and that's where we will take our grievance. As head of a branch of the government, as head of the judiciary, a chief justice has some structured channel of communication with the head of state. And if there is none, it will be really for me to establish that structure, channel of communication, which will involve all the 3 branches of government, because that's how governments work. A government has 3 legs like an African traditional stool. So those legs are the same. And if one is short, then you can't comfortably sit on that stool. So the eventual port of call will be at State House.
That is all, Chair. Thank you, and thank you, my Lord.
Thank you.
Thank you very much, Honorable Judge Majaja. Thank you, Your Honor. We'll now take a short break, 10 minutes, and we'll be back at 11:30. Thank you.
Thank you, Chair.
General here by virtue of my office.
Thank you, Mr. Attorney.
Your Honor, I'm Olive Mugenda, Commissioner representing the public and also chairing these interviews. Welcome.
Thank you, Chair.
We also have Honorable Anne Amadi, who is the Chief Registrar of the Judiciary and Secretary to JSC.
Good morning, Judge.
Good morning, Your Honor.
Also, we have Frida Mukaya, who is the Registrar of JSC at the corner there.
Thank you, Your Honor.
So once again, welcome, Judge. A few housekeeping issues. Please be precise in your answers as much as you can so that we can manage time. And I'm also asking my fellow commissioners to also be precise in their questions and also keep within the timelines that we have decided. Your Honor, feel free to ask for clarification if you're not sure or if you didn't hear the question properly, so that you are able to answer the questions properly. After 2 hours, we are going to take a break, and Anne Amadi will come for you to take you where you're going to have your break. Or maybe you can even go to your office because it's around here.
Yes.
Okay, so you now start with the interviews. And I'll start, Your Honor, by asking a question. We have read your very impressive CV. You have done a lot of work for judiciary the last 30 years. And in 10 minutes, because the rest of the details will come through the questions, but in 10 minutes, please summarize why this commission should nominate you for the position of CJ.
Thank you, Chair. Thank you, Commissioners. I joined the judiciary in 1987 as a district magistrate, professional. That's what they were called those days. In those 34 years, I have risen through the ranks to become a judge of the Court of Appeal where I am today. 3 years ago, my colleagues in the Court of Appeal identified me to be their captain and unanimously elected me as their president. As I steer the Court of Appeal, I'm pleased to tell the commissioners here that the court, despite the numbers which we are all aware of, has done a great job under my leadership. The court has been able to put in place case management systems that has seen it reduce the backlog in that court. When I took over, there were 7,000 or so appeals pending. 2 years later, and we had and finalized 3,000 through active case management. Unfortunately, the numbers kept dwindling. COVID-19 came, and these numbers have started rising, heading back to 7,000, 8,000. The Court of Appeal, under my leadership, is regarded as one of those courts that are most collegiate, where judges work together. There's chemistry in the way we work. The Court of Appeal is also known for delivery of robust decisions. But all this has been because of my leadership, because when I took over, we identified as a court the gaps, one of which was the backlog at the time, the delays in judgments. We had judgments that had been pending from our court up to 3 years undelivered. We took a deliberate decision together that all those judgments, we sat in June of 2018, April 2018, and we agreed that by June 2018, we must have all those judgments delivered. So when we assembled in June again to review, we noted that we still had a few left. The judges had worked really, really hard to reduce the backlog of delayed judgments. So we extended time to August, and by August, all those judgments were delivered. As I speak to you today, Commissioners, there is no delayed judgment in that court. Perhaps 1 or 2, 5 months or 6 months, again through leadership of myself. How did I get to the Court of Appeal? And I want just to ask, when I was elected by my colleagues, I was not the senior most. In a list of 20, I was number 13 in terms of seniority. In terms of age, perhaps the same number. And so they saw something in me that they identified with, that they thought would make a difference in the court, hence the unanimous decision to pick me as their leader. And I want to trace my journey to the Court of Appeal from the time I joined in 1987 as a district magistrate. As a district magistrate, again, I was identified, having worked only for 1 year, working in this very building as a district magistrate and dealing mainly with criminal cases. The chief magistrate at the time, Mr. Justice Mango, identified me to head the traffic court. And he told me in particular that that court had had problems of integrity. Each time a magistrate was posted there, it became a toll station. And he said, I want you to streamline it. He made me in charge of that court. He asked me to ensure that more traffic courts are established in Nairobi and its environs, and I did that. 1 year later, while still a district magistrate, I was promoted my second year in the judiciary to the position of resident magistrate. Hardly had I done a case than I was called by a team of JSC members, just 2 of them, Mr. Justice Nyarangi, who was then in the Court of Appeal representing that court to the Commission, and Lady Justice Joyce Alwach, who was representing the High Court. When I got a call that I was required to go before them, my reaction was panic, because I didn't know why I was required before the Commission members. With them was Mr. Justice Mwera, who was then the registrar of the High Court. That's how they were called, a misnomer, because the registrar of the High Court was really the chief registrar of the judiciary at the time. With them again was Mr. Jacob Olekipuri, who was then the deputy to Justice Mwera. And I was told that the two had their hands full as administrators. The more we were expanding, but the administration only had 2 people to help the Chief Justice, so they wanted a third hand. The truth of the matter was that Mr. Justice Mwera was being elevated to the High Court, and Mr. Jacob Olekipuri was taking over as the registrar. So they picked me as a deputy to Mr. Jacob Olekipuri as the deputy registrar. Working in administration, which I did for 17 years, exposed me to many things. While serving as chief court administrator, which was the highest at the time, actually had just been created, I was the first person to occupy that office, and 2 others did after me, or 3 others. I was exposed to many things in the court system. I made so many reform initiatives that we enjoy up to this day as a judiciary, and I just want to give a few examples. The medical scheme we are having today, it was my brainchild, and this is how it happened. I'll be very brief. As judges, magistrates, and other judicial officers and staff, we were being paid a medical allowance or up to the standard of your cadre. all put together under the printed budget came to something like 20 million. And then we had also a line called ex gratia medical, which came to about 30 million. I worked out these figures. We commissioned a healthcare provider, and I approached PS Treasury with these figures of 50 widely among our colleagues, and I traded off. I said, take away the medical allowance that is in our salary, and take away the ex gratia vote, and we get a medical cover. And we started off with one officer alone, first year. The second year, an officer and a spouse. It has grown today to an officer, a spouse, and I think 4 children. Per diem that we today receive when we travel, official duties, again my brainchild, because people were surrendering impressed. You are given 10,000 to go to Kisumu on official duties. You only spend 3, but when you come you have to account for 7. And you'd see all manner of receipts. It was quite demeaning even for judges. And if you didn't surrender, then of course next trip you would not go. Again, I negotiated this with the PS Treasury at the time, and they changed it to per diem that we enjoy today, so you don't have to account every a day is costed, and if you go for 10 days, you're paid equivalent. Apart from those two, in administration, I also took part in many reform initiatives. I was appointed a joint secretary to the Kotut Committee by the President of the Republic, the late Daniel Arap Moi. And Kotut Committee was formed to delink or to address issues of terms and conditions of service of the judiciary. The Kotut Committee made a report that completely delinked the judiciary from the mainstream civil service. The judiciary, for years, from independence, was an appendage of the Attorney General's chambers. All our staff, all secretaries, clerks, executive officers, all were seconded from the Public Service Commission to the judiciary. With the Kotut Committee and the report, this came to an end, and we adopted, so to speak, those who are seconded to us. Hence, that's the time we started using PLS 1, PLS up to I think 12 or 13, which have now been converted under your organization review. And that's how we delinked completely from the mainstream public service. The other thing we wanted to do after the Kotut, I was part of the implementation committee that was to implement this, was to completely identify our needs. And one of those needs was to try and have our own pension scheme, away from the one that is enjoyed by the civil servants. I will, if you ask me later, I'll be able to say more about this. I then was appointed as a secretary again to work in the famous Quach committee, again dealing with issues of judicial integrity. Again, after that, I was part of the implementation team that was implementing the recommendations. Finally, a meeting was called by the then Minister for Constitutional Affairs, the late Mutula Kilonzo, with the Chief Justice at the time, Honorable Mr. Justice Gisheru, and Emeritus Attorney General Amos Ouko. Of the Court of Appeal judges at the time, a few High Court judges, and Law Society, and many players in the justice sector, the issue was reform. At the time, reform was in the air. This was after the Kriegler Commission and all that. In that meeting, again, I was perhaps the youngest and perhaps the most junior. I was asked to chair a task force that was appointed to look at the reforms in the judiciary. That task force was multi-sectoral. The current Speaker of National Assembly was a member. The Honorable Mr. Justice Lenaola of the Supreme Court was a member. Senator Okongo Mogeni was my vice. And I can go on, and it was multi-sectoral. Apart from myself and Mr. Justice Lenaola, most of the members were from outside. We did our work, and that work is reflected in Chapter 10 of today's Constitution. This commission, as constituted today, was recommended in that task force. And so many other things that are in that chapter came from the task force. So, Chair, I believe that with my qualification, that with my training in court administration, with all the things I've done to bring change to the judiciary, that I'm capable of moving this institution from where it is to another level. I thank you.
Thank you very much, Your Honor, for that explanation. My second question is regarding your time in judiciary as an insider, Your Honor, and you interacted closely with Emeritus Judge Mutuga and also Emeritus Judge Maraga, and both who came up with great initiatives, great blueprints. So my question is, what reasons do you think interfered or affected their ability to implement those blueprints to, fully? I'm asking that because there are still gaps. I mean, there's still ICT issues, there's still case management issues. So what affected, these great ideas not to be implemented fully?
Thank you. Correct observation. The two Chief Justices did great jobs. Chief Justice Mutunga laid a very firm foundation on issues of access to justice, built many courts, opened up the engagement, employment, and appointment of judges and staff. He did a great job in this institution. And Chief Justice Maraga picked from there and has also done great things. He has brought sense of independence to all of us who work in the judiciary. But as you said, each one of them came with a blueprint, building on each other. And these blueprints, when you look at them, Mr. Justice Mutunga's blueprint, JTF, has 4 pillars, which are more or less replicated in the 6 pillars in Mr. Justice Maraga's SJT. Reform process is indeed a process. It is not a one-off thing. Even those jurisdictions that have developed, they have gone stage by stage. But I think really a critical look at the approach. I think there's a bit of distraction because we are coming up with too many other things. If you look at the policy documents that we roll out, which are all meant to further these reforms, I think they take us off. And I think we need to really, really focus on those recommendations that are aimed at enhancing access to justice. So I would say that we need to just focus and, of course, prioritize those that are low-hanging fruits, and those that are medium term as well as long term. Once we identify them, we should be able to see the movement clearly. But as it is now, there are many, many things happening around us, very useful things. Perhaps the coordination. I thank you, Chair.
Your Honor, you have talked of focus and coordination. Money was not an issue that we should maybe also address?
Thank you. Yes, money has always been a big issue ever since. Even when I was the accounting officer, money has been a big issue in the judiciary. Just to digress, up to 2003, just before I was appointed a judge of the High Court, the budget of the judiciary was 800 million. We had not reached $1 billion. Out of the 800 million, we were expected to raise in appropriations in aid 300 million. The Exchequer was therefore giving us only 500. This has really grown, really grown. It's to some of us who worked in the judiciary in the early days, this is really a dream come true, that now you can talk of 17 billion to the judiciary. But the judiciary has also grown in numbers and in activities, and so money is very critical in reform. Thank you.
Thank you, Your Honor. How would you describe your leadership style? Are you democratic, maybe too democratic? Are you authoritative? How would you describe yourself as a leader, Your Honor?
I am very democratic. And my colleagues in the court will tell you, no decision is taken from my office alone. Just to give you one example, everything we do in that court is done as a team. I'm just a leader. We looked at the number of applications pending in our court, 1,700 applications. Some were filed 4 years ago. Applications for stay, for injunction, simple applications. After I identified the problem as the team leader, I assembled the judges and staff, and I told them this is the problem. I knew what I wanted. I wanted us to clear this backlog of applications. And proposals came from the floor. We want to hear these applications. Can we list? Normally we list only 4 applications. I wanted to push them a little to list 6. It came from the floor that we list 15. Again, it was reviewed to 9. And we went out, and in 16 days, we had done 600 applications. And results are out there, rulings delivered. One thing, again, we agreed as a court is to borrow what the Supreme Court has adopted. The applications, you don't have to do 13, 15 pages. These are applications that are run of the mill. And so we agreed we would reduce the number of pages, and we were able to achieve. So through consultation, through teamwork, the court has been able to work together and gel very well.
Thank you, Judge. There are no times when you put that authoritarian hat at all.
Oh, yes. Sometimes you cannot, even as a democratic leader, there are times, a time comes when you have to insist that what you think is best for the team is what has to be done. And sometimes, yes, I do.
Thank you. My last question, Your Honor, is again checking your CV. I noticed that you are a member of the Judiciary Honors Committee since 2018. And one of the candidates that we have interviewed this week, Your Honor, said that there's no criteria, and if it is there, it's not well known, which determines or which, so that one is able to predict who qualifies for that award. So my question is, again, look at your CV, Your Honor. I realize that you got the Order of the Burning Spear, EBS, in 2019, and also got the higher one, which is the Order of the Chief of the Burning Spear, in 2020. That is two very heavy honors in 2 years. So in 2 consecutive years, because there's nothing wrong with the honors. I think you deserve them. But then when they come in 2 consecutive years, my question is, much as you may be deserving your honor, was this due to your membership of that committee, or how did that happen? And number 2, could you have given a chance to one of your other colleagues in the judiciary who deserve to get this honor, so that you don't get 2 of them consecutive? And I'm saying this, Your Honor, knowing that you don't give the awards yourself. Your committee was recommending, but I'm just thinking that it looks a bit odd that you're honored 2 consecutive years. Maybe you can explain to us.
Thank you. Yes, Chair. I am a member of the Honors Committee that is chaired by the Honorable the Chief Justice. We have only had 2 or 3 meetings. There's an Act of Parliament that deals with honors, and there's a criteria that is used to award honors. And we are just advisory as a Judiciary Honors Committee. We forward names which are received from different courts, different divisions, from different cadres to the National Honors Committee that I think is chaired by the Deputy President. It is there that they now choose who to give. And so it's not, we make a recommendation. Why I ended up with the 2? One, because it was realized that the honor that had been given earlier was lower than the level a judge ought to be given. So we made a case for the judges of the Court of Appeal, because they're the only ones who are getting that lower grade. So when we sent the names afresh to be given those honors, only myself and I think Mr. Justice Kiagi got the higher one. I don't know how they picked the 2 of us and left the rest. So it's not that I used perhaps my membership in the committee to do this. This is, it's quite, perhaps it's not very transparent also. We simply write to the courts, to the directorates, to nominate those they want to be awarded these honors. And from the list, we don't make any amendments, we send it as it is. Amendments are done in the National Committee. And we give everybody a chance. In my court, a secretary got, because she's outstanding in her work. Thank you.
So if you became CJ, it is an area that you would want to work on so that hardworking judges and judicial officers also get these honors. It is something you would want to improve, maybe come up with a criteria, maybe people can apply if they feel that given certain qualifications or achievements they deserve. Is it something that you might want to change?
Yes, because I don't know how each unit identifies those to be brought to the committee. We need to make it also very transparent from those units that everybody in the court, if it's magistracy, let all the magistrates know that this is happening this week, and we are nominating those we think have distinguished themselves. And so it is something that should be given as a reward for some achievement and not for any other consideration.
Okay, I think I'll add there, but just a disclaimer, Your Honor, that some of us have those 2 awards. My only problem was the consecutive years, so, yes. But you have explained, and thank you very much.
Thank you.
I now request Acting CJ to continue with the questions.
Thank you. My Lord, just before we leave that point of the honors, you have described to us what you've done in your long service in the judiciary. Is it not true that the Chief Justice has in fact never chaired any of the honors committees, and that in effect you are actually the chair, my Lord?
I can't say that the Chief Justice has never chaired. The retired Chief Justice asked me towards the end of last year to chair on his behalf, and I've chaired 2 meetings. So I do not know. That was really my first interaction with the committee, so I can't tell whether there were earlier meetings.
No, I'm talking. This is important because not only did Judge raise it, you know there are mamas in the institution. You live here, don't you? So you know what our people have been saying about those honors. So I think it is a topic that we ought to make closure about, and this may be the opportunity.
I agree.
Emeritus Chief Justice Maraga, for the last 2, actually for the 4 years that he was here, he did not chair an honors committee meeting. He always delegated that to judges, and you are one of the judges to whom chairship was delegated in the last 2 years of his term. That's my concern, because I want to ask one other question on the issue. Is that correct?
Yes, as I said, I really do not know the circumstances under which the retired Chief Justice asked me to chair. I thought it was a temporary thing. I didn't know, because under the Act, he is the chair.
He is the chair under the Act. Let us confine ourselves to the period you were chair. He never chaired during your membership, did he?
No.
No, he did not. And therefore, that would be a serious place to start reform. You agree?
I do.
As Chief Justice, my Lord, you would be the Chief Judge and the Chief Administrator of the institution of the judiciary. Is that a correct statement?
True.
Let for now our concern remain with the Chief Administrator. You have got to administration quite early in your days in the judiciary, correct?
Yeah, true.
As early as?
1989.
Since then, you've been, my Lord, in internal leadership of the institution of the judiciary. Now, being specific to yourself, forget the committees out there. Please tell us what your specific contribution has been to the benefit of the institution internally. I heard what my Lord said about the pension. I heard what my Lord said about the medical. But this institution is concerned with more than those 2. My Lord would agree?
Yes.
So, as regards, and I heard what my Lord said about being president of the court for the last 3 years, and what the court as a team is doing under my Lord's leadership, correct?
Sure.
So now, my Lord, would you give us specific achievements under the 2 heads, administrative and judicial, for that period, my Lord?
I said I have served in administration for 17 years, and in administration your duties are confined to the management of the court, staff, provision of tools of trade, facilitating the judges and staff. And as I said earlier, for administration there is a lot that I did, I just mentioned two. I can also add pensions, as you've raised it. We started following the issue of pensions in the 90s, and there's one thing that has remained as a scar in my heart, that we've not been able to bring it to closure. But I'm pleased to say again that there's a lot that was achieved also. The magistrates and staff, magistrates and the other staff now have a separate scheme from the public service scheme. Is a contributory superannuation scheme, and that was as a result of my work in the committee that was looking at it. It is that committee that made a proposal to the Retirement Benefits Deputy President and Designated State Officers Act that introduced an amendment to include in that act, because it was taking so long to get the judge's pension running, to include the Chief Justice and the Deputy Chief Justice in that act. My contribution as a magistrate was really brief. I only rose up to RM, and when I became a High Court judge, I believe my decisions when I was fasted to Malindi, I made decisions regarding the purpose and objective of using assessors in criminal trials, and I made a very strong case that it was not useful if the courts were not going to use their opinions to arrive at a determination of a criminal trial. And I believe as a result of that, I saw more or less a few years later, the use of assessors in criminal trials were deleted from our statutes. A very useful thing, something, if you asked me, we can go back to, but make their opinion useful, rather than just have them there give an opinion that you can rubbish. I made decisions regarding when I was in the High Court, regarding the use of confession before magistrates, and I thought that to confess a crime before a magistrate who is presiding in a criminal case was to take a magistrate to be part of the investigating team. I thought personally that it was not in order to call a magistrate to go before another magistrate under a trial within a trial to say that I did not torture, I did not promise. I made a decision to that effect. In Nakuru, I made another decision that has gone all the way, my lady, to your court, Supreme Court. This is a wildlife-human conflict, where I made a decision that it is the role of KWS to ensure that wild animals remain where they belong, and that if they escape and harm human or interfere with human activity like agriculture, then KWS is responsible, a decision that was upheld. In the Court of Appeal, I've also made my contribution in the jurisprudence of that court, and I have shared with the commissioners some of my decisions, among very many others.
Thank you, my Lord. As Chief Administrator, my Lord will be required to ensure that there is full implementation to the greatest extent of the policies that guide the
of the Supreme Court. Should he be successful in the interview, Ngatia will become the second CJ to be appointed from outside the judiciary after Dr. Willie Mutunga. Now, the 64-year-old senior counsel with 2 master's degrees and profession was ranked the top lawyer despite resolution by the global chambers in 2019 and is well remembered for arguing the case that resulted in the abolition of the mandatory death sentence. Now, Murimi Mwangi is at the Supreme Court. Murimi Mwangi, what else do we know about Fred Ngatia as he appears before the JSC this morning?
Certainly a lot to expect from senior counsel Fred Ngatia as he defends his suitability to be the country's independent Kenya's 15th Chief Justice. Certainly a lot more in terms of the issues that the Judicial Service Commission will be placing against Ngatia, including potential petitions that might have been filed against him. But perhaps most outstanding is for him to explain his connection to the President Uhuru Kenyatta administration owing to his twice representation of the president here at the Supreme Court in election petitions challenging his election in 2013 and 2017, and how that feeds into the whole concept of the independence of any time from now. So perhaps we cross over there now.
Good morning, Council.
Good morning, Commissioner.
I'm Patrick Shohei, representing Public Service. Karibu.
Asante.
Good morning, Senior Counsel.
Good morning, my lord.
I am David Majanja, Judge of the High Court, Commissioner representing Kenya Magistrates and Judges Association. You're welcome.
Thank you.
Good morning, Senior Counsel.
Good morning, Commissioner.
I'm Olwande Evelyn, Chief Magistrate. I'm the female representative of KMJ.
Asante.
Good morning, Senior Counsel. My name is Machari Anjero. I represent the Law Society of Kenya.
Good morning, Commissioner.
Good morning, Senior Counsel. My name is Felix Koske. I represent the public.
Asante, Commissioner.
Morning, Senior Counsel. My name is Mohamed Warsame, Judge of Appeal. Welcome.
Asante, my lord.
A very good morning, Senior Counsel Fred Ngatia.
Good morning,
Kariuki. I am the Attorney General, and I'm here by virtue of that office.
Asante, sir.
Senior Counsel, and I'm Olive Mugenda, Commissioner representing the public and chairing these interviews. We also have the Secretary to JSC and also the Chief Registrar of Judiciary, Honorable Anna Madi.
Good morning, Senior Counsel.
Good morning, CRJ.
And we also have Frida Mukaya, who is the Registrar of JSC, at the corner there. Thank you. So a few housekeeping issues, Senior Counsel. Please feel free to ask commissioners to repeat a question if you're not sure or to clarify. After 2 hours or so, we will have a short break, and Madam Anna Madi will escort you to where you're going to have your break. Otherwise, it's supposed to be a conversation, Senior Counsel, so should all relax and have the conversation. So I'll kick off the interview by giving you 5 to 10 minutes, Senior Counsel, to tell us why you feel you are the best suited candidate to be CJ. And I will just 5 to 10 minutes, because the other issues will come with the commissioners. Thank you.
Asante, Professor. Perhaps I should first and foremost say I started my legal career at Attorney General's Chambers in 1980. That was the first place I was employed. Within a relatively short period of time, I was allocated very many difficult briefs. I'll mention only 2. I was involved together with the head of station, or head of my section, Mr. Frank Shields, with the acquisition of the land where Kasarani Sports Complex is constructed. The owners of that parcel of land, a company called Salopia Limited, had objected to government acquiring that land
because we were using the Land Acquisition Act. And it's a prerequisite in that act that when government is using that act, it's got to be for a public purpose. And because of what was then happening, the owners were saying, this is nothing more than government taking this land for its own purposes. We did overcome that formidable challenge, and after overcoming that challenge in the High Court, then we went on to the issue of compensation. It was handled by the chief valuer, and that is why this republic has a near Olympic stadium at Kasarani. Soon thereafter, Attorney General nominated me to look at a very difficult problem that has persisted in this country, or had persisted in this country from the time of independence. That is the difficulty of an international boundary between Kenya and Sudan. Entrusted with that task, ultimately, government, together with the British Council, sponsored me to undertake a Master's in Law program at London School of Economics, and as part of the LLM program, to undertake original research in Kenya-Sudan boundary. I was at LSC. I spent numerous hours at Public Records Office because commissioners, all the documents of this republic during the colony and protectorate status, all those documents are at Public Records Office. I'm sure commissioners, you know where Public Records Office is towards Heathrow Airport at Kew Gardens. So I had to commute from LSC, which is at the Strand, and go to this Public Records Office every other single day, and I acquired a wealth of material. In 1 minute, commissioners, at the turn of towards 1914, the boundary was defined by the British government as a straight line between two fixed points, or in the alternative, such a line that would give to us the customary grazing grounds of the Turkana. Those grazing grounds were never defined, but towards 1938, a survey party established that the boundary was slightly above the straight line. That was not to be. We went on, and Sudan demarcated what they call 1950 Sudanese patrol line. That Sudanese patrol line is what actually triggered my interest in this area. And by application of principles of international law, I actually established that when any government allows a competing government to administer an area, the doctrines of acquiescence, doctrines of renunciation of territory, they all kick in. I hope we'll have an opportunity to discuss this in greater detail, but in one sentence, we were able, or I was able in my research, to establish that the Sudanese patrol line, which is a considerable distance from the straight line, is now the international boundary. So, commissioners, I'm sure you all remember, in 1980s, the Kenya-Sudan boundary was indicated as a straight line. Then in 1985-86, we had an extended boundary that went towards Sudan. The difference in graphic terms is that through this research and the validation that went on in government, we were able to change our international boundary from the straight line to the new boundary, and we acquired 9,608 square kilometers. To put it in context, 7,400 square meters. So we acquired a territory larger than the former Western province. This is one of my research papers. It went through government, it went through validation. I cannot say that it was singular effort. the Attorney General and other organs of state all participated, and ultimately we changed our boundary. Practice from 1987, I've conducted numerous cases. Of interest would be I acted for ECK in the Kriegler Commission and also in the Waki Commission, where it was demonstrated that weak laws, weak institutions, weak governance structures can actually collapse any republic. Kriegler Commission report demonstrated and illustrated the weaknesses which were within our legal system and the lack of capacity in the electoral process and the lack of independence in the judiciary. I was part of a team. My team leader was John Musyoka Annan. I was his able assistant, and we also had Nyamodi. Paul Nyamodi is one of my colleagues. A team of 3, we represented ECK. It was a gigantic effort. We learned so much about the need to have proper laws and proper capacities in key institutions that deal with elections and the need to have an independent judiciary. Professor, thereafter, I've given my CV. I was instructed to work for National Assembly, and this is interesting, against the Senate in an advisory opinion at the Supreme Court. You may remember that there were the tough wars at the beginning of the 2010 Constitution, which is the superior house. But like lawyers, we do what we know best. We posed what appeared to be a very innocuous question. Which house should originate a money bill? But behind that innocuous question was whose business is it to legislate division of revenue bill? Because if it came to be my client, National Assembly, to legislate division of revenue bill, it means then we're in total control over devolution. And Senate was saying, no, it can't be. It is a joint effort. We came to Supreme Court, we argued on this matter. I lost, but with one dissenting judge saying that the issue was not justiciable. With that loss, devolution became entrenched as a principle that must be followed. But that was not the end of it. Barely 2 years ago, I was again instructed by the Council of Governors also about division of revenue bill. This time because the opinion that had been given to both houses was being ignored. I did that matter, and the Council of Governors was quite happy with the outcome. In between, I have conducted many other cases, and in my view, if I could summarize in 1 minute, you've had a CJ from academia who did wonderful work. I've looked at his transformation agenda. Allow me to say this with tremendous respect to my former lecturer. It is as profound or second in as profound to the Constitution. I can't see any other agenda as profound as Chief Justice Mutunga's agenda. Then you had a judge of this court as a Chief Justice with his agenda, which took us to another level. We have more magistrates, more judges, courts all over the country, a wonderful experience. But what you now lack is somebody who has been a consumer of this service. I've been knocking at the doors of the High Court, Magistrates Court. I've been to all the courts in this republic. I have had that eye that no other would have. For 40 years, I've been in Magistrates Court everywhere. I've been as far as Lokitang. I've been in every part of this country. We had 14 High Court judges at 2011. I've been to each of those. I've been to every Court of Appeal station in this country. Supreme Court started, I was one of the early practitioners in that court. I have practiced in that court. I have wonderful professional relationship with the judges of that court. And I do believe, Professor, that I have that eye, a practitioner's eye, that can be able to see the real weaknesses and the perceived weaknesses and come up with a transformation agenda slightly advanced from access to justice. From access to justice to another agenda that would be, which we will discuss as we get along. Thank you, Prof.
Thank you very much, Senior Counsel. Clearly, Senior Counsel, you are a successful lawyer, Senior Counsel by all standards, given what you have told us and also what you have read from your CV. What I haven't heard, as Senior Counsel, that I want you to explain to us is I've not seen much evidence of Mr. Ngatia, the leader. So please demonstrate to the Commission and to the public that you are that transformative leader we are looking for. I'm interested in tangible achievements in leadership and also maybe institutional changes that you have done, and that can be attributed to your leadership excellence, Senior Counsel.
Thank you, Prof. Prof, of course, I must also acknowledge your transformation of an ordinary college to iconic status. So allow me to pick a college, a university college, as an example. I have so many examples, but allow me to take a university college. Commissioners, you may all recall, University of Nairobi, virtually every now and then students will go on strike. It became so perennial that we were wondering whether we should have a university next to the human population around the city of Nairobi because of the rampant wastage that used to happen. About 3 or 4 years ago, I was requested by the Senate to look for what are the issues bedeviling this university. Prior thereto, I had been involved as counsel in a lot of disciplinary cases that went to the High Court. And those disciplinary cases used to have almost a circular effect. You discipline a student, expel him, and then that provokes a riot at the campus. You do not do that, then again another circular effect. And when Senate engaged me with a student population of 80,000, I started working with the university administration. Prof, at University of Nairobi, there are 8 colleges. No, sorry, there are 6 colleges. Each college had its own independent disciplinary process. So you'd have a college, for example, Humanities and Social Sciences at the main campus, with near to 18 faculties under it. You have another college, say, Biological Sciences or Agriculture at Kabete. Each of the 6 colleges would have its own disciplinary structure. Then for the halls of residence, there were 8 distinct. Consequently, Honorable Commissioners, you have, so to speak, semi-autonomous pockets of disciplinary bodies all dealing with the 80,000 students. And of course, what will go to the academic, the colleges, would be anything to do with academic, but for residential, it's what would go to the halls of residence. I studied this, I engaged all the colleges, we had seminars, and we had so many workshops. And then I looked at comparative colleges like Pretoria, Harvard, my former college, LSE, or University of London, and I actually saw what is the problem with this premier university. It's the 7th university in Africa, but they had not got it right. You cannot have a disciplinary process So what was ailing this college is the fact that there was no harmony in the sentences that are awarded to students. There's no harmony in what is a disciplinary offense. And I crafted a student handbook that was to operate and is to operate across board. So you do not have a student in one college being expelled, whereas for identical offense or misdemeanor or transgression, he is just told, do not repeat that again. Consequently, and I say this without any fear of contradiction, the harmony you now see at this university is a direct attribute of the work that we did. I must, of course, acknowledge that I've received tremendous support from the Senate and from all the college principals and all the academic staff. We were able to actually transform what was becoming more or less a perennial problem of indiscipline to now a college where I'm sure commissioners, you cannot recall the last time you saw university students throwing stones along Koinange Street. And I have many, many other examples of equal kind that I've had occasion to deal with.
So, Senior Counsel, were you the chairman of the board of the council of Nairobi University? Or?
No, whatever work I did as an consultant.
Oh, okay.
I did as a consultant at the request of the Senate. I was reporting to the Senate, and they authorized me to have meetings with any person within the university. So I started off with the academic staff, and then went on with the college heads, and then as we went along, I got across a very, very good idea of why indiscipline had become the order of the day.
So, just a follow-up question, Senior Counsel. You're going to be leading a workforce of probably like 5,000 judicial officers and judicial staff. So how will that experience then help you to lead this big workforce in the judiciary?
The principles, Prof, commissioners, apply for a workforce of 20, and they would apply for a workforce like the Boeing aircraft manufacturer. It is all a question of how you are able to be a leader. I should have indicated that later in life, I did a second master's degree in applied philosophy at Strathmore University. In that I learned business ethics, philosophy as a tool, and leadership really clearly understood what you are looking for are the 4 cardinal virtues. The 4 cardinal virtues are prudence, temperance, fortitude, and justice. If you have the 4 cardinal virtues, you'll be a leader of 10, a leader of 100, a leader of administrative skills is leadership. And in leadership, you are looking for the 4 cardinal virtues. And this is an applied principle in all the blue chip companies all over the world. We had an empirical research at Strathmore about who are transformative leaders in all the companies in the world. And what stands out is somebody who manifests in deed and in word that you have the 4 cardinal virtues. I can say without any fear that I have tried my very level best to manifest and to inculcate the 4 cardinal virtues in everything I do. Before I conclude, from the 4 cardinal virtues, you collapse into 2 other, so to speak, abilities that you must work on, which is humility and magnanimity. So from the 4 cardinal virtues, on a day-to-day applications, there must be humility and magnanimity.
Okay. Thank you, Senior Counsel. You talked about the vision a little bit when you said that you move from transforming judiciary from access to justice, move it forward a little more. Please talk a little bit about that, your vision, all the stakeholders behind you to achieve that vision.
As a consumer of the service, as a consumer of this service, And here I must say that as a consumer, I have that little more knowledge because I've been to virtually every court. And we are able to see how that court operates, how another court operates. I've been a victim of delayed judgments. I've been a victim of all manner of things. And with like measure, I have a lot of very good things to say. Before I say, let me acknowledge, Prof, that in our judiciary, we have some of the best legal minds. And I do not say this in flattery, because I have had the occasion in my second master's program to do a research paper on jurisprudence in apex courts all over the world, on very, very toxic or very difficult subjects that happen in our life. This is the end of life litigation. I've looked at America, the Supreme Court of America, Supreme Court of all the countries in the world. We have fantastic judicial minds. What is it that I'll be able to bring which is not there? Access to justice was very well done by the first Chief Justice. Second Chief Justice did as much as he could. But access to justice is both qualitative and quantitative. It's not enough to have courthouses. It's not enough to have many judges and many magistrates and many tribunals and everything. What we now need is another transformative agenda: expeditious disposal of cases. Expeditious disposal of cases is the one that will take Kenya to the next level. It is heartening to hear of cases staying in the court processing, being processed in court for 10 years. We should be looking at a possibility of a case, and we can do this, and I've listened to other Chief Justices. I'm a keen listener of the Chief Justice of South Africa, Mogain, and what he's trying in South Africa is a case management system that can process a case from filing to the determination of that case. Why we must have this is because without it, we will never know statistically how well we are doing. That would be my mission and my agenda.
Okay. Thank you very much, Senior Counsel. One last question. You have said that you have avoided to be a conspicuous consumption person. But please explain what you meant, because looking at your wealth declaration, Mr. Gatti, I saw very high-end cars. So isn't that conspicuous consumption, or what did you mean?
No, Prof. Conspicuous consumption has many aspects. I meant social circles. I meant that I am not in social circles. I'm not in lots of the new approaches in life. I do prefer to hold to my own. I being in a library as contrasted to being in a social circles. And I must say I'm one of those lawyers who are not on the social media, any of the social media platforms. I'll prefer to hold my peace, and therefore I indicated I'm not in those social circles. And I do not mean to say that those who are any less or doing any worse. It's a question of choice.
I'll now request Commissioner Mwilu, Acting CJ, to ask you further questions.
Thank you. Let us conclude the discussion, Senior Counsel, that you have begun with the Chair on leadership. And that leadership must of necessity lead to the reforms that we have already begun and which must be continued. And since you appear to admire Chief Justice Mutunga, let me start at that point. On the 19th of October 2011, when Chief Justice Mutunga was addressing the judiciary and the nation at large, he said the following words, and I quote him, "We found an institution so frail in its structures, so thin in resources, so low in its confidence, so deficient in integrity, so weak in its public support, that to have expected it to deliver justice was to be wildly optimistic." Now, we want you to please put that into context, Senior Counsel, in terms of the transformation being undertaken, but the transformation that Senior Counsel would progress, were God to grant that Senior Counsel becomes the 15th Chief Justice of the Republic.
Chief Justice Mutunga, I think, was being very philosophical with certain words. Being low in public support, I can see that as a direct attribute of the events 2 years or 3 years prior thereto, where the public support to this level, culminating to a presidential candidate declining to have his dispute litigated in court. And with that came lots of other events. And one of the issues that I would wish to deal with, and that is why I would wish to gain public support, is that if a case is filed on 1st January, within that year, it should be concluded. Commissioners have also done a little bit of reading, and we have real-life problems in this country. I saw for example, in Costa Rica, an empirical study which has been done. If you get your criminal justice system working quickly, there is an immediate reduction in crime. But here, what we do is the exact opposite. We make our justice system work so slowly. Consequently, there can be a reduction in crime. If we wish to get public support, expeditious disposal of cases becomes a very important thing that we must implement. Deficiency and being thin on resources, I see that happening because it's at that time of Chief Justice Mutunga, I think judiciary had not had its pride of place in the Constitution. We also have the history we are dealing with. When I was joining Attorney General's chambers in 1980, judiciary was a department under the Attorney General. And that is why in the Waruhio Commission, he actually makes a direct recommendation: let judiciary be away from Attorney General's chambers. Therefore, the transformation journey not only is to divest or to have judiciary stand on its own under the Constitution 2010, but to also have its own independent funding structures. And again here, DCJ, I would wish to say all those tools are provided for because there is a judiciary fund. And the Constitution of Kenya only establishes 3 funds: Consolidated, Judiciary Fund, and the Equalization Fund. Consequently, the framers of this Constitution want us to get away from the frail judiciary which was there in 2011 to a very robust judiciary, which is where we want or would aim to have this judiciary get into. I see Chief Justice Mutunga's words as words of hopelessness and frustration in one word, because across them it is the hopelessness of the situation that he's being confronted with.
Senior Counsel, then you would of necessity have to take us out of that hopelessness. Are we still there? That was 2011. Fast forward to 2021. Would you still describe the institution of the judiciary to be in a state of hopelessness?
Far from it. We have made such tremendous progress.
And therefore, then, Senior Counsel, what would be the role of Senior Counsel, were you to be Chief Justice, to move us from here to a place better than what Senior Counsel would have found by the time Senior Counsel was retiring as Chief Justice?
I see myself being in more or less the same position as Singapore was in 1980. Singapore had a huge backlog of cases. I have done a special reading of Singapore and the backlog of cases. And within 4 years, and everything being equal, I'm a Chief Justice of 4 years. Within 4 years, Singapore did overcome that backlog. But not only the backlog, simultaneously they put in place the process or the system I am craving for, that cases are being concluded within a relatively short period of time. Today, Singapore, commissioners, is being cited all over the world. They did this with some assistance from the World Bank, but I do believe, with or without that assistance, they had the mental, they had the determination to do it on their own. It's one of the shining examples of what can be done within a relatively short period of time within a judiciary that really is interested in moving forward. So to answer you directly, DCJ, I'll be the Chief Justice that will end the backlog and simultaneously have the expeditious disposal of cases, not as a theory, but as a practical thing. I would wish to see a criminal case started and within 6 months there is a determination. I would not want to be the Chief Justice of criminal cases staying for so long that witnesses disappear and acquittals are because of the delay in the justice system.
Thank you. I think let us pursue that a little. The justice chain players. How is my Lord Chief Justice Ngatia going to achieve a criminal determination within 6 months? Will Chief Justice Ngatia force magistrates or judges to go on with hearings where the other justice players are not playing ball? It is advocates who at times will seek adjournments. I'm aware the court is in control or ought to be in control of the case, but there will be genuine reasons for an adjournment. There will be other maneuvers undertaken by the other justice players, the investigator, the prosecutor, so that the case is not ready and therefore not able to be finalized within this period of 6 months that Senior Counsel Ngatia proposes. What then, what then would Chief Justice Ngatia do to actually achieve a determination of criminal cases within 6 months?
Thank you, DCJ. Like everything else in life, it's not a one-man show. NCAJ becomes the first port of call. The beauty with NCAJ is that all the other players are involved. And it has got to be from NCAJ that a determination has got to be made that we must move this country forward. Judiciary actually comes at the tail end in, for example, the criminal justice system. Coming at the tail end, there is very little you can do. The investigations are done elsewhere. The indictment, the charges are done elsewhere by a constitutional office holder. There's so much prior to alignment in court that becomes almost determinative to how long the process will take. So I will do my very best at NCAJ to say that we must take this country to another level. I would want to get as much cooperation from the other actors, because they are real actors in this system, and without their cooperation, there's nothing that can be done. But the unfortunate thing, Commissioner, says this, that the person who gets the blame from the public is not those other actors, it's the judiciary. And when, for example, and I've done this as an empirical study, when adjournments are also sought by the prosecutors, and they are sought over and over again, a month goes, 6 months goes, a year goes, the person who gets the blame is the judiciary. And those who applied for adjournments do not want to say they caused a delay of 1 year. So it's got to be a collectivity. And the key word here is collectivity of action. And that collectivity will be at NCAJ. But here, at the end of it all, is a question of whether we want to go the Singapore way, which to me is the correct way, or whether we would want to just stay with what we are doing, which to me is the incorrect way. We must have expeditious disposal of cases.
Thank you. If Senior Counsel were to be Chief Justice, you would have, at the very least, 3 very core functions. There are more, but 3 core. But considering the whole 5 or maybe 6, which would Senior Counsel consider to be the most important role, if that is a possibility, of the holder of the office of Chief Justice, and why would that be considered to be the most important role of the office of the Chief Justice?
As I look at the Constitution, my obvious answer would be the first and fundamental role of a Chief Justice is the head of the judiciary. Being the head of the judiciary has its own far-reaching consequences. You therefore become, so to speak, the titular head, not just the titular head, but the real head, the policy head of the entire judiciary. It's by virtue of being that head of the judiciary that you also have the second hat of presiding judge or the president of the Supreme Court. That role of president of the Supreme Court is a role that I have trained myself for. It's a role that can be played or can be assumed by a practitioner of my standing, and the other roles would be the other commissions, this commission being one of them, NCAJ being another one of them, Council of Law Reporting being yet another one of them, and commissioners. I do have that which it takes to be able to have enough time for all those roles.
Which leads me, Senior Counsel, to the next question. And it is the question of balance between the many roles that the Honorable the Chief Justice is required to execute. How would Chief Justice Ngatia balance between those roles, and what would guide Chief Justice Ngatia in the balancing act between the roles. You have identified that of the head of the judiciary as, to you, the most important one, but that must not make the others suffer. And therefore, what would be the balancing act? Part one. Part two, the Chief Justice, and you've mentioned that, being the President of the Supreme Court, must ensure, in my view, that that court works. Must ensure that as the final court, what comes out of that court is indeed final in nature, so that it reads the nation and so on and so forth. So balance between the execution of duty of the various roles of the Chief Justice to be able to make yourself an effective Chief Justice?
Thank you, DCJ. As head of judiciary, as I indicated, that's a leadership role. And the beauty with it is that in this judiciary, we have very well established structures, statutory structures, which are very well established. And the Chief Registrar of the Judiciary is the accounting officer. It's not my role to try and micromanage that statutory duty. But I do have an interest to ensure that it's well done. So my first port of call would be the leadership advisory committee, because I would want to carry the entire judiciary or to be with the entire judiciary. I'll regard that as my cabinet. Being my cabinet, I'll be able to know what is going on in the Court of Appeal, in the High Court, and courts of similar jurisdiction. In all probability, we should also have a magistrate with us. The CRJ is with us. Heads of directorates are with us. I would want to have very structured meetings with all of them, because that is the cabinet. And with that cabinet, because I'm still ultimately the one reliable, I should be able to know what is going on at every level of this judiciary, including the Cathy's courts, and including how many tribunals have transited and what we are doing about it, and including the improvements we can make, like small claims courts and how we get them going. So it's not difficult for me, because I have with me a dedicated team that I do hope I'll be able to work with quite effectively.
Thank you, Senior Counsel.
But if I could explain about the Supreme Court, because you had also asked me about the Supreme Court.
Yes, please.
The Supreme Court, being a collegiate court, I'll be one amongst equals. And what I'll do from day one is to personally call all the Supreme Court judges, and we shall have a meeting as equals. Collegiality, commissioners, does not mean, and I must say this, it does not mean that I impose my views on them. It does not mean unanimity in decisions. That's not what collegiality means. And we, as a Chief Justice, I'll try to have very robust engagements by the judges. I'll not stifle them by telling them, look, let's decide this way. Sometimes, in most times, by having individual opinions is the growth of law. But if you stifle it by having unanimity, you are not going very far. But of course, in such certain very divisive topics, like say racial segregation, you'd want to have the entire court with you. But with the ordinary cases that go to the Supreme Court, I would want the individual judges to actually show their best. If I could digress a little, we remember Judge of Appeal Nyarangi because of his individual opinion in Motoves Aurelian. And we cite this to my Lord every other day about Judge Nyarangi said this, and we all remember him for that. In other words, individual opinions do immortalize judges, particularly if they are well done. I'll be able to balance that work because of my deep desire in development of law. Law is my passion. Instead of other pastimes, I would have time, even in the evening, to read and to generate my opinions. And even in that court, the Supreme Court, I'll try to have the same thing, expeditious disposal of cases.
Thank you very much, Senior Counsel. Let's go to a different area now. You must have come across someone called Montesquieu. You will tell us who that guy is. Tell us what he said, what is he known for, and how does that relate with interdependence?
Very good. That's cause for me to quickly remember my reading in philosophy. Up to around 17th century, I may be mistaken, maybe a little earlier, man was living in what can be described as state of nature. A state of nature meaning there was no community or there was no law and order. That state of nature meant you are on your own. Consequently, life was very short, very brutish, very violent. Because of living in that state of nature, although lawyers want to take advantage of this, it is actually philosophers who actually saw a need of moving from the state of nature and to live within a community. And the first, if you could allow me, DCJ, before we go to Montesquieu, the first philosopher who saw the need to move from the state of nature to a community is John Locke. John Locke, or either John Locke or Hobbes, it's John Locke, who actually said that much as we want to go to a community, there are certain rights we cannot surrender. The first right we cannot surrender is life, liberty, and property. But we can surrender other rights of protecting ourselves. We surrender them to this community or this body politic that we create. So those three rights which could not be surrendered are today the rights we talk about, which cannot be alienated. But soon after John Locke came Montesquieu. Montesquieu said, even as you move from the state of nature, there's something you are missing. The first thing you are missing is absence of a body that can make laws. Because yes, we are moving now to a society, a community. We have an absence of a body to make laws. Next thing you are missing is an impartial judge. The third thing you are missing is somebody to enforce the laws. So Montesquieu, a French philosopher, is the one who is credited the world over by having the separation of powers. Separation of powers is not a lawyer-driven exercise or initiative. It came from these philosophers of the 17th century. That separation of powers was quickly taken over, as well as the three rights which cannot be surrendered, and the Thomas Jefferson, as you may recall, in his Declaration of Independence, he ran away with it, and in America, the Declaration of Independence which was done, I think, in 1770-something, had the three rights. Right to life, liberty, but then he twisted, Thomas Jefferson twisted the property, and he said, pursuit of our own happiness. So the Declaration of Independence of America is a direct attribute of those philosophers. I hope I have answered you fully.
Save for we would like you to say something about what Montesquieu said, and which I think you have sufficiently explained, related to interdependence.
Interdependence, the beauty with interdependence, therefore, even at Montesquieu level, you have the three powers, for lack of a better word. One creating the laws, another one the impartial judge, and another, the third one enforcing. And this become the legislature, judiciary, and the executive. Their interdependence is that you, as the executive, you require the laws to be enacted by legislature. And as a judiciary, you become the impartial arbiter of any dispute that will arise, either horizontally or even vertically. And in that, I see, as a matter of fact, that is the same thing that is today known as the separation of powers within our Constitution. The interdependence meaning that you are not isolated. Could I say this? Judiciary is not created for itself. Judiciary is created as a service industry to the people of Kenya. So if it's understood we are service industry for the people of Kenya, we are not created for ourselves, then we become interdependent, because the people we are serving are the people of the Republic of Kenya. Both executive, both legislature, and more important, the 47 million or 40-something million of our citizens. That is our core business.
Thank you, Senior Counsel. I have two final questions. And the first one will be as follows. Would you say that the jurisprudence emerging from the Supreme Court confirms the transformative nature of the Constitution, or it belies it? And while there, while still at the Supreme Court, the Supreme Court has exclusive original jurisdiction to hear and determine disputes relating to the elections of the office of the President, arising out of Article 140 of the 2010 Constitution. Please, with the reference to Section 83 of the Elections Act, the various amendments thereto since 2016, and any other relevant jurisprudence that comes to your mind, Senior Counsel, please discuss the role of the Supreme Court in the nullification or confirmation of a presidential election. And please tell us whether that jurisdiction should rest in the Supreme Court, and what the challenges of hearing that important case are to the judiciary as a whole.
DCJ, you put me in a small fix, but I'll navigate. I'll definitely navigate these very difficult areas. The first one is easy. Supreme Court has come up with some very transformative judgments. Very, very transformative. Let me say this. The Murwateto case, although misunderstood and misapplied by courts in Kenya, has won the pride of place all over the world. I do not have, but I can provide to the Chief Registrar I was just going through my searches around Moroateto. It is quoted with approval in Barbados. A whole paragraph of Moroateto is quoted with approval. Not just Moroateto, but a whole paragraph of how the Supreme Court came to arrive at a decision that a mandatory death penalty is an illegality. But having said so, I think I could say a word or two about it. In Moroateto, which I had occasion to argue, the question was not about death penalty as such. The question was about a colonial relic. In 1938, the colonial masters inserted Section 204 in the Penal Code. They did the same in other colonies, Malawi, Zambia, Belize, a few other colonies. But at the turn of independence, those other countries had amended their law. But in Kenya, 40, 50 years later, we still have this Section 204. My attack was on a mandatory death penalty, not the question whether a death penalty is constitutionally viable. It could be viable. But a mandatory death penalty means that we are sharing our judicial power with the National Assembly. Judicial power cannot be shared. The unfortunate thing, Commissioners, is this. I think Supreme Court didn't make it as explicit as it could that this applies only to sex. Simple reason, the Supreme Court thought you can bring into place other actors like Attorney General to come with proposals. Hopefully after they have come with proposals, then Supreme Court will give further directions. As fate would have it in this country, there is a word called lethargy, and after a year, the year that Supreme Court thought that the report would be there was no such report. I lost track with the Moroateto case. But I do know as a fact that what Supreme Court would have wanted to do was not done because the other players in that who are defined by name failed to do that which they were supposed to do. But it's not too late. In the event that you honor me with this position, I'll immediately get to Moroateto, see how the judges who could hear it or to come to terms with how we now do not allow it to be a way of people running away from what are otherwise valid sentences.
Moroateto Senior Counsel is one case. Another one that is transformative?
Another case which would have been transformative but didn't become as transformative as I thought was the arbitration appeals. Because we lost the opportunity of Kenya attracting arbitrations from all over the world like other countries have. That case was going towards making arbitration insular from judicial intervention. The Supreme Court almost reached there but backed out by saying that go back to Supreme Court and let Supreme Court see whether it was. So those are the two that would immediately come to mind. As regards presidential election petitions, could I start off with the challenges? The first challenge every Kenyan would say is the 14 days. It's not a challenge. We have done it 3 times. We have done it because lawyers in this country do believe that you can do tasks within a relatively short period of time. I say this in contradistinction to what happened in Zambia. In Zambia in 2016, they have the same law. The lawyers took 10 days, exchange of papers, another 2 days, case discussions and case conference, and they remembered they have not had their case on the 14th day. So the presidential petition was not heard. It was not heard because they started saying that can there be extension of time? Needless to say, the lawyer for the successful party said it's cast in stone, it's cast in the Constitution. So I do not see that as a major problem. Section 83, DCJ, in 2013, it was applied fully. It's on the basis of Section 83 that the election was upheld substantially. Come 2017, there were difficulties. The court, the majority decision did not apply, as I remember, Section 83. Dissenting judgment, I believe, of Supreme Court Judge Joki dealt with it. But then there was an amendment by National Assembly. Many things were done. The amendments have been struck off, I remember, by one of the petitions by Katiba Institute. So we are in fairly murky waters about the application of Section 83.
Who should start hearing that case, Senior Counsel?
Sorry?
Which court should?
A presidential petition, I would, without reservation, say, should be the sole preserve of the Supreme Court.
Reasons?
We have a lot of similar jurisdiction. Malawi, as you know, has the similar jurisdiction. They nullified the presidential petition, I think, last year. If we do presidential petition in any other court, then there will be issues about appellate processes. I do believe Supreme Court has won its pride of place by having dealt with 3 presidential petitions, and in all 3, the actors may have had reservations, but by and large, is now an established jurisprudence of the Supreme Court.
Now, to my final question. Right now, as we are sitting here, there is the debate whether or not the 15th Chief Justice of the Republic of Kenya ought to come from inside or from outside, the insider-outsider debate. What is your view of a practitioner, in effect an outsider, at this particular time coming to head this very important institution? Justify your answer with some basis. And that will be my last question to you, Senior Counsel.
Thank you, DCJ. Maybe let me start with the last. United States of America, which has the pride or prides itself as being the most liberal democracy, from 1896 to 1953 had racial segregation as part of its judicial policy. Schools were on racial basis. A black boy, black girl will go to a black school. Similarly, a white girl, white boy will go to another school. Public transport was in the same way. Supreme Court in that country was divided for over 70 years. They had several judges, eminent chief justices. They could not see that segregation is an archaic practice. 1953, General Eisenhower nominated Warren as the Chief Justice. Let's look at Warren. Warren was a very successful lawyer, had conducted numerous prosecutions in the United States of America. He was one of the most brilliant lawyers America had seen. He then transitioned to be the governor of California. Was a governor, I think, for 2 or 3 terms. In 1952, this Warren man was so popular he thought he could stand as a president and sought the nomination of the Republican Party. He was defeated by Eisenhower. He subsequently became the Chief Justice of the United States of America. I emphasize this insider-outsider difference, how difficult it then becomes. Warren is coming from a lawyer who became